Conflict of laws. It is that part of law which comes into play when the issue before the court affects some fact, event, or transaction that is so clearly connected with the foreign system of law as to necessitate recourse to that system. Conflict of laws embraces those universal principles of right and justice which governs the courts of one state having before them cases involving the operation and effect of the laws of another state or country. Conflict of laws is that part of the municipal law of a state which directs its courts and administrative agencies, when confronted with a legal problem involving a foreign element, whether or not they should apply a foreign law or foreign laws. What is a conflict of laws case? Any case which involves facts occurring in more than one state or nation, so that in deciding the case, it is necessary to make a choice between the laws of different states or countries, is a conflict of laws case. When the word state is used in conflict of laws, what does it mean? It includes not only foreign sovereign countries or states, but also political subdivisions of states or countries which have their own legal systems, such as the different states constituting the United States of America, the United Kingdom, the federal states of Australia, Canada, and Germany. Why is this subject more important in recent times than in the past? With the fast advance of modern technology in the means of communication between and among states, the rapid growth and expansion of international trade and commerce, the influx of tourists and foreign traders to our country, as well as the massive migration of our countrymen to work and live in foreign shores, the great increase of business transactions of foreign corporations in the Philippines, all these bring about many and varied problems in conflict of laws. Hence, the necessity not only for lawyers and judges, but for our citizens as a whole to study this subject as an important department of law. Is conflict of laws part of international law? No. Although it is sometimes thought of as part of international law because of the presence of a foreign element in a given problem, it is not international in character, but it is part of the municipal law of each state. By municipal law in conflict of laws is meant the internal or local law of each state, since every state has its own internal or local system of law, so each state also has its own conflict of laws. What is the reason for the diversity of conflicts rules among the different states of the world? This is because each group of people have a language, culture, mores, and customs, religion, ideals, and beliefs peculiar to such group, which are reflected or expressed in their laws and legal systems. For example, while the great majority of the countries of the world allow absolute divorce, our country still has not legalized absolute divorce. And while some countries are very liberal in granting divorces, others are not so liberal. Distinguish conflict of laws from public international law. As to persons involved, public international law governs sovereign states and entities that are internationally recognized or possessed of international personality, such as the United Nations Organization, while conflict of laws governs private individuals or corporations. As to nature, public international law is international in character. Conflict of laws is municipal in character. As to transactions involved, public international law applies only to transactions in which only sovereign states or entities with international personality are concerned and which generally affect public interest, while conflict of laws deals with transactions strictly private in nature, in which the country as such has generally no interest. As to remedies applied, in a dispute between sovereign states or international entities, or in a case of a violation of international law, the concerned states may first resort to peaceful remedies like diplomatic negotiations, mediation, inquiry and conciliation, arbitration, judicial settlement by international tribunals like the United Nations, and if these remedies fail, the states concerned may resort to forcible remedies like severance of diplomatic relations, retortions, reprisals, embargo, boycott, non-intercourse, Pacific blockades, collective measures under the UN Charter, and finally, war. In conflict of laws, recourse is had to judicial or administrative tribunals in accordance with the rules of procedure of the country where they sit. What are the sources of conflict of laws? We have direct sources and indirect sources. For direct sources, bilateral and multilateral treaties and international conventions, constitutions, codifications and statutes, judicial decisions, and international customs. Indirect sources, the same as other branches of law, among others, the natural moral law, and the writings and treatises of thinkers and famous writers and jurists on the subject.